Hello and welcome to our February 2018 Expertise in Business webinar series. I'm Eric Hobbs, President of Technology Associates, and I'll be your moderator for today. Today's topic is wage and hours matters and looks to be a fairly popular topic just judging by the signups that we've had. I'm lucky enough to be joined by Mimi Sewell from Sewell Employment Law located here in Raleigh. And Mimi's firm works with companies of 100 employees or less here in North Carolina to provide employment law and human resources compliance advice, prepare employment-related contracts, and help defend employers against employment-related claims. So first, some housekeeping. If you have questions, enter it into the chat box, and I will get those organized and over to Mimi. And to let you know that our next webinar is going to be on Tuesday, March the 13th, and our topic is going to be exempt versus non-exempt and avoiding pitfalls of employee classifications. And just to let you know, Mimi's been nice enough to actually do a 3-part webinar series, so she'll be our presenter for the next 2 webinars. So if you want some more information on that, go to our website, technologyassociates.net/registration. So with that aside, we'll jump right into our topic. So Mimi, you there?
I'm here. Thanks, Eric.
Outstanding, outstanding. So we've got a lot to get through, so we're going to jump right into it, and here we go. So a couple things we're going to hit today, really around tools, how to help ease the hiring process, questions that we asked in the interview, documentation, both mandatory and optional in the new hiring process, best practices for dealing with calculating and distributing time off. We'll talk about bonus payments, how they should be paid, how they should be distributed, and situations and policies that prevent paying accrued paid time off. So first thing we want to do is I'm going to give just a quick kind of overview of things that we do to help improve hiring around technology and tools, and then I'm going to bring Mimi in for the more interesting topics around employment law. So for us, really a couple of different things. Number one, job listing, then workflow. We'll talk just a sec. Documentation history, templates, and job posting boards. So we use a tool called Applicant Stack. And along with this, a couple things we do. First and foremost is making sure that we've got the proper job listing, both topic and summary. And something that we learned fairly early on is unless you are naming the job, what the people are looking for, you're not going to get a lot of registrations. And I'll give you an example. We were looking for an inside sales position, and we titled it Appointment Setter. And that's just not what those people who do that job look for. So we got virtually no submissions on it. We did, however, change that to inside sales, and all of a sudden we're blown up with listings. So keep that in mind when you're doing those listings. And then also on the summary. So we found that being as explicit as possible around what makes the company special and why somebody would want to apply there helps increase our submissions for job candidates. So second, Applicant Stack is what we use. There are a bunch of different tools out there. Just let you know, Applicant Stack runs $50, $60 a month, something like that. For us, the other part of that is workflow. So as you're creating jobs in an online platform and you're posting them out there, you want to have some stages set aside so you kind of know where you're at in the process with individual candidates. For us, we use new, then screened, and then interview, and then a couple of the steps after that to help kind of keep organized on where we're at with specific candidates. Documentation history, a big thing with an online applicant tracking system like that. It's easy to put in notes around candidates, maybe why you did or didn't invite them in for a face-to-face interview, what they were like on the phone. Most importantly for us is being able to easily identify people who have reapplied in the past. So before implementing a tool like this, you'd get a resume in and you're like, geez, this person sounds really, really familiar, but I can't remember talking to them. And by having that online applicant tracking system makes it a ton easier on you. And then the last two things, templating and job posting boards. So in our system, we've put the work in up front to template our job postings and email communications that goes out to various candidates, setting up face-to-face interviews, sending the link to the online application, letting them, sending them disc assessments. All these things are templated, so it's an easy and quick process for us to just go in and click, 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 and move candidates along into in our system. And then lastly, if you're using an online system like we do, once again, Applicant Stack, it's very easy to do job board postings. So basically you can create a job and then put your templates in place for the job listing and the questions that you want to ask, and then just click, yes, put it on Indeed, put it on all these, Glassdoor, all these different places. You can do those free, or you can get featured postings if you do have an account with that. So those are just kind of some of the quick things up front that I wanted to share with you folks on what we use to make this process a little easier. And with that, I'm going to turn it over to Mimi to talk a little more with respect to employment practices law around hiring. So Mimi, take it away.
Thanks, Eric. Again, thanks for having me. And everyone, if you've got questions, don't hesitate to shoot those over to Eric, and we'll try to get through them as best we can. Just a few quick points. Eric, if you'll move on to the next slide, just to talk about preparing for a job interview. And generally, most small employers have a set list of questions that they ask all applicants. And what I would typically advise is sometimes you may want to clarify or adjust those questions in order to make sure you're asking the right questions to find the best person to fit that role. So what I would suggest is think about your current employees perhaps working in the role that you're interviewing for or a similar role. Think about maybe the personality traits or their work performance traits that make them a fantastic employee. And then back into appropriate questions that you can ask to elicit information to determine if that applicant has those same or similar personality traits or work performance traits. So just as a quick example, let's say that one of the traits of some of your stellar employees working in a particular role, or one of those traits is that they have just a natural patience when communicating with clients. And so perhaps an appropriate question to ask an applicant to see if that applicant has a similar trait is asking them if they can give you an example of an interaction with a difficult client or customer and how they resolved it. Or perhaps you could give them some sort of hypothetical situation around that issue and ask them how they would handle it. So I think that if you can come up with appropriate specific questions, it might also help you minimize the length of those interviews. And last key piece is figure out the right interview process that works best for your business. Some businesses have a simple process where their HR director, HR manager handles the majority of the interview process. And then perhaps some of you have a process where both the HR manager and the direct manager or direct supervisor of the particular position handles the interview process. And then a third option that I'm seeing a lot of small businesses utilize is more of a team approach. So after the HR manager identifies appropriate candidates, perhaps then the next interview is with the direct manager. But then there's a third interview where the applicant actually sits down with the team of employees that they would be working with. So think through what, depending on your culture or your kind of day-to-day administrative ability, but think through what would be the most appropriate process for your business. And kind of along those same lines, Eric, if you'll move to the next slide.
One quick thing, and I kind of forgot to mention here, your first point, identifying the characteristics of your ideal applicant, and we've done a lot of work on that, but really it kind of comes back, what we call it is kind of core values, right? Because one of the reasons you want to ask those things is you're guaranteeing to that applicant and to your employees, hey, these are the type of people who are employed here, and I'm going to surround you with these type of people, right? This is what it means to work here. And I think the better connection you have, and if you ask those questions up front around your core values, the less likely you are to have a misfit based on just values, maybe on technical expertise, right? But you can overcome that. But a misfit in
Right.
values is really hard to overcome, right?
Absolutely. Absolutely. So if you think about it, core values or personality traits, those are things that are innate to an applicant.
And
The
that's an easy
technical
way to,
piece to
to
it,
discover those core values is identifying the characteristics of your ideal current employee, right? The folks who are in your company
absolutely.
now who are the best. Your core values exist in that person, whether you have listed them on a whiteboard or not. They're there. They're in your company, and if you can get those out and put some questions around identifying those things, and one of our core values, number one core values, is we always find a way. And our question around that is hey, tell me about a time you faced huge odds, or you were trying to do something people told you couldn't do, and what happened, right? And see if
That's
they've
an
got that.
absolutely perfect example.
Great, awesome, thank you.
Yeah, and I agree with you. I think those core values are the key, and then some of the technical skills are things that can be trained or can be improved upon. So
Right.
absolutely, I think your example is perfect. Um, so just depending on what your interview process is, think through, and it's kind of key that you train all of your managers, or if you're doing a team interview or of the applicant, make sure that all of the employees involved in that interview process understand how to conduct the interview, and in particular, understand what you should talk about in an interview or questions you should ask, and then things that perhaps we should avoid. And we'll get into a few more details on that in the next slide. But I think a key piece here is just identify what works for your business, and then make sure we train everybody that's involved on how we like to conduct our interviews. A big key component when you interview an applicant is not only to have a series of questions perhaps in front of you, but have the actual job description for that position in front of you. And all of your questions should really come down to, can that applicant perform the duties of that job? So referring and keeping your questions and keeping the applicant on pace, and always going back to what you have written in that job description will keep you on focus. And kind of to Eric's point just now, and talking about core values, one thing that a lot of small businesses don't focus on in the interview process is selling the actual business, the culture, the core values, and then the benefits that the applicant should be aware of working with your small business. So it could be simple things like, do you allow remote working? Do you focus on wellness? How do employees engage and work together? What are the benefits of not just actual things like insurance and vacation, which we focus on a lot, but those intrinsic benefits and culture that make your business unique. And then another key point to also make clear in your interview is to really establish if there are any specific company expectations of that role or that position. It could be a sense of, this position involves a high level of trust, or it could be as simple as, attendance expectations. If this position requires that employee be available to work overtime hours, on weekends, after hours, on call, things where you can establish the expectation, even on simple things like attendance, is key to highlight in an interview. And then the final point here I wanted to make is, whenever you're in an interview process, we all take notes. And this is where training for all of your managers and employees really becomes key. We take notes often because, to Eric's point, sometimes we're going through a lot of different potential applicants for a role. And so we're taking notes to make sure that we can go back, review those notes, and put a face in our minds with the information that we've written down. One thing I want to caution you on, though, is to be careful about the notes that you take, and try to only take notes that pertain to that employee's ability to perform the job. So one thing that I've seen come back to bite small employers is notes that can be perceived as discriminatory. And we don't mean for them to look or feel that way, but sometimes they unfortunately can be perceived that way by an applicant that we choose not to hire, and who may come back and file a discriminatory claim saying you failed to hire me because of my protected status. So let me give you an example. I had a client that interviewed several applicants for an office-related position, and one particular applicant who applied for the job, who had a great interview, happened to come in with a cane. The individual who was taking or performing the interview for the company happened to just put a notation in the corner of her notes that said cane. Now, throughout the course of the interview process, they ended up interviewing several folks who were qualified for the role, and they hired a different applicant. Well, the individual who had come in with the cane ended up filing a discriminatory claim, basically saying that the company failed to hire that employee because of her disability. And the issue that we had to get around was the fact that the notes that the interviewer had taken actually indicated that she remembered the cane in her notes. Now, from the business owner's standpoint, the fact the applicant had a cane was completely irrelevant. That particular note was just taken down to help the interviewer remember which applicant walked in, and to try to review her notes to choose the right person for the role. Had nothing to do with the applicant's physical ability or disability. So the key here, guys, is if you're going to take notes and you want to write down something to help you remember an applicant, try to choose something like the color of their shirt. Nothing that has to do with their the way they look, their ethnicity, or anything that could be attached to a disability, like a cane. Okay, so let's move on to the next slide and talk just a little bit about things that we perhaps shouldn't ask or discuss during an interview. And a lot of these items, these are just sort of a few items. So I have a more complete list if anyone would like a copy of that. And it's not necessarily something you want to take into an interview with you, but it's something that would be good for training purposes for your managers and employees. So feel free to let Eric know or email me directly if anyone would like a more detailed list. But generally speaking, so we want to avoid questions that an applicant could perceive as inappropriate or discriminatory, especially if we choose not to hire that applicant. So things like, how old are you? When were you born? When did you graduate from high school? Now, one key thing I want to point out here is that some jobs require that an employee be of a certain age. You have to be 18 to work this job. You have to be 21 to work this job. So if that is a requirement of the position, then it is absolutely okay to ask, are you 18 years old? Are you 21 years old? So ask the specific age requirement, but don't ask an open-ended question about how old someone is. I hope that makes sense. Second kind of key thing, try to avoid questions that have to do with parenting, adopting, fostering, and pregnancy, of course. Now, this doesn't mean that if you have an individual that comes in who's obviously pregnant, it's not that you can't ask about, when she's due. So there are some exceptions to this rule, but from a general standpoint, you should avoid asking those sorts of questions. Of course, religious affiliations, generally, what someone's religion is has no bearing on their ability to perform the job. The only exception here is that if you are a church, a religious institution, then the state and the federal government give you a lot more leeway to ask questions regarding a religious affiliation. Of course, medical history, disabilities, any medical benefit requirements, these are things we definitely want to avoid during the interview process. Now, one question I get a lot is, what if my job does require a lot of physical activity? Can I ask if the employee is able to perform those physical activities? And the answer is yes. This is where your job description that you have a copy of in your interview becomes very important. You can put the job description in front of that applicant, ask them to review it, and if physical requirements are very important for your role and essential for an employee to perform, then you need to have those physical requirements outlined in your job description. And you simply provide the written job description to the applicant in the interview, and you ask them to review it and ask if they're able to perform. Of course, you avoid issues or questions about ethnicity, nationality, and then finally, drinking or drug abuse. So let me clarify this. You can ask if an employee is currently intoxicated or currently an active drug user. Those things, as employers, we want to make sure we avoid. The one key thing here is if someone is a recovering alcoholic or a recovering addict, then you have to keep in mind that if we ask these questions, those recovering individuals can actually be protected under the Americans with Disabilities Act as a disabled employee. So we want to perhaps avoid asking those questions unless there's something that occurs during the interview that causes us to feel the need to ask. Sorry, Eric, did I miss a question or something in there?
No, I just thought it was funny. So we can ask someone in an interview, are you drunk right now?
You sure can. Hopefully you all will never, ever have to do that.
There are several that I've wanted to ask that question of.
Okay. Well, yes, you definitely have the right to know if someone is currently drunk in your interview.
Yeah. So 2 questions I kind of routinely ask, and let me run them by you and see if I'm stepping on anybody for this. First thing we ask is, hey, what do you like to do when you're away from work? And the other thing we ask is, you know, if we go to the next step, we're going to do a background check. Do you have any issues with that? So are those 2 okay?
Both questions are perfectly fine. The one thing to keep in mind when you ask someone an open-ended question, what do you like to do, you know, when you're not working? This is where we have to also understand not just what questions perhaps not to ask, but maybe discussions on topics we should avoid. So let's say when you ask that question, the person responds and says, well, I'm very active in my church, and I've been, you know, the Sunday school teacher at First Baptist Church for the last 30 years, okay?
Mm-hmm.
They may think that is key, something that expresses dedication or, you know, some key element that will show you that they're going to be a great employee. What I would refrain from is going down the path of asking any follow-up questions on their religion or their affiliation with the church. Again, assuming that you also are not a church affiliation or a church organization. So for your purposes, Eric, it's perfectly fine to ask those open-ended questions. Just be cognizant of things you may not want to continue discussing depending on their answers.
Gotcha. Makes sense.
Yeah. So one thing, Eric, if you'll move to the next slide, one thing that lately you all may have seen in the news are prohibitions on asking applicants about their salary history. And so the question is, can we ask about that in an interview? And the answer is, it really depends on where your company is located and the state or local laws that govern that issue, that govern that particular issue. So right now, there are several states that have taken the stand, and cities that have taken the stance that asking about salary history can actually amount to essentially gender discrimination. And the concern is that women typically have been underpaid in comparison to men, and that if you ask a female applicant her past salary history, and then ask a male applicant his past salary history, that you might offer the male applicant a higher salary for the current role because if he had a higher salary previously, because you know that you'll have to match the previous salary often to entice an applicant to accept your offer. So the concern is that by asking salary history, we might base our current offer on that history. So there are a few states that have created local legislation prohibiting employers from asking. Those states are currently California, Delaware, Massachusetts, Oregon, and then Puerto Rico. In addition, there's several cities who have also developed their own local laws on the same issue. New Orleans, New York City, Philadelphia, Pittsburgh, and San Francisco so far. Here in North Carolina, there is no state or city prohibition to asking about salary history. So technically, we can do that here in the state. One other key thing I wanted to mention that you all may have also seen in the news has to do with some guidance issued by the Federal Trade Commission and the U.S. Department of Justice about a year and a half ago, 2 years ago. And they issued specific guidance for folks working in an HR role. And the concern has to do with companies that are competitors, essentially, who are communicating about what they pay similar employees. And the concern is that these companies are chit-chatting and deciding what they're going to agree to pay certain positions. And the Department of Justice and Federal Trade Commission, the concern there is that it creates sort of a price-fixing, anti-competitive environment.
Now, is there a differentiation there on really price fixing in any trades? Because if I call up a peer and go, "Hey, look, we're looking to add this position. I know you've got this type of person. What should I be paying for this type of person?" I mean, that's not really collusion, right?
In theory, no, but the Department of Justice and Federal Trade Commission would probably find fault with that.
Wow.
So the exceptions really are, can you gather that information through an unbiased third party? So many
like
of you
a salary survey outfit.
Exactly. So if there's an unbiased third party that's gathering that information, and you can review that information, and by looking at it, you can't identify specifically which company that's a competitor of yours provided that information. And to some degree, they want that information to be slightly old. So they don't want it to be today that information was gathered, but maybe 6 months ago. So the one exception, really, primary exception to this issue has to do with those kind of wage salary surveys. Yeah, but great question.
And maybe one more in addition to that, just real quickly. So we've used salary.com in the past. Have you, A, used it, and B, found it helpful or accurate?
I actually am not familiar with that particular website, so I wish I could speak to it. Eric, I'm sorry, I don't have any guidance on that particular resource. Why don't we move on to talking about new hire paperwork? I get a lot of questions from small business owners on, what do I have to provide an employee when I hire them? And there are kind of two buckets as I like to think of them. One is, forms or documentation that's basically mandatory under state and federal law that we provide our employees. And then the second bucket is sort of new hire paperwork that's optional. And if we provide the paperwork, there are kind of some key things on when we provide it to them. And usually first day or first week is when we want to do it. So starting with mandatory new hire paperwork. In North Carolina, state law requires that when we hire a new employee, we have to provide them on their first day with the information on when they're getting paid, so their pay days, their rate of pay, how much we're paying them, and how we're paying them. Are we giving them a live check? Are we paying them by direct deposit? In North Carolina, because of this requirement that we are obligated to pay, the statute doesn't say that we have to provide it in writing. But just like with every other obligation, the only way for an employer to prove that we've met that statutory requirement, if we're ever challenged, is to have that information in writing, a documentation that we can use as a defense. Couple quick points. If you provide your paydays as sort of like an every other Friday concept, that's perfectly fine. But what you want to do is when you hire a new employee, you want to actually let them know when their next payday is so that they know when the every other Friday starts. Or you can actually provide them with a list of exact paydays for that particular calendar year. The other key thing to mention here is payment method. This varies state by state, but in North Carolina, you can force employees and require that you pay them by direct deposit. So you can force employees to have a bank account and pay by direct deposit. That differs state to state. So if you have employees outside of North Carolina, that piece, you might have to provide them with the option of a live check versus direct deposit. A couple other forms that are required. Of course, your tax forms, your NC4 and W4. If you do have direct or require direct deposit, then you want to make sure you provide your direct deposit form for the employee to provide you with their bank account information. Federal law requires that all employers have complete Form I-9s. This is your form that employees fill out to indicate that they are eligible to work here in the United States. Section 1 of that form must be completed by the employee on day 1. You as the employer have to fill out Section 2 within 3 days of employment. That form is not filed with any government agency. You as the employer are obligated to maintain it in your office. If you offer any sort of benefits, health insurance, life insurance, disability insurance, those types of things, make sure you include those benefit enrollment forms. New hire reporting. North Carolina, like most states, requires that you notify the state when you hire a new employee. The purpose often is so that the state can find folks who might not be paying child support payments on time. So most new hire reporting, if you work with a CPA or a payroll service to process your payroll, most of those companies are filing that new hire report with the state of North Carolina on your behalf. I would double check if you do have a payroll service or you do work with the CPA to manage your payroll. I would just double check with your provider, make sure they are reporting your new hires. If not, and you are doing that in-house, there's a simple online registration for North Carolina, and when you hire, all you have to do is log into your account and update your information. If anyone has questions on that, I'm happy to provide the link. If any of you, like Eric mentioned, if any of you run background check if you run background checks, then you need to make sure under federal law that you're having all employee or applicants and employees sign a background check authorization form. So you have to have the permission of the applicant or employee before you can run that background check. And then finally, one key thing I just want to mention here, most of you are probably aware that under federal employment laws and North Carolina employment laws, there are certain posters that we have to put up in our offices. Well, the question I often get is, what if I have employees that don't report to my office every day? They work remotely. So if you're hiring an employee that works remotely for you or primarily remotely for you and is not going to be reporting to your office where they could see your beautiful, lovely labor posters in your break area, then what I would suggest is you actually print those posters out. You can print most of them for free off the Federal Department of Labor website and the North Carolina Department of Labor website. Print them out and provide them as part of your new hire packet for that remote employee. And then on an annual basis, as we're updating those posters in our office, we would probably want to provide updated copies to those remote employees as well.
And I think this is even complicated even further if your remote employee happens to be out of state, which is something that you kind of specialize in. It's something we did a long time ago, and it was, oh my goodness, the regulations and the letters we got were just unbelievable.
Absolutely. So great question, Eric. So if you are a company here in North Carolina, but you hire employees out of state, you're obligated to comply with the labor and employment laws of the state where your employee is actually providing services for you. So if you do employ folks out of state, you do want to make sure not just that you're looking at the employment posters and information required by the other state, but you also want to look at all of your employment policies in your handbook to make sure that your policies are compliant under the other state's local laws. So excellent point, Eric. All right, so let's move on to optional new hire paperwork. So the list here, everyone, this isn't necessarily documentation that's required, but let's kind of talk through them because sometimes it might be documentation that would be helpful. So a lot of small business owners will provide either applicants with an offer letter or once you hire them with a welcome letter. So you want to probably put together a template document for both of those so that you're only adjusting the specific information relevant to that employee. So for example, your template offer letter would have a section where you'd fill in the job title, the start date, the initial salary that you're offering or hourly rate that you're offering. One thing to refrain from is any kind of promise language in your offer letter or anything specific, some sort of promise language. Let me give you some examples before I move on from there. So a lot of times you'll see in an offer letter language that says your salary while you're employed will be X. So what that creates is an argument for the employee to say, at no point can you change my salary. Under North Carolina law, employers have full control over the salary or the hourly rate that you provide, as long as you meet minimum wage requirements. So you don't want to create an issue where if you needed to, you can't reduce or change an employee's salary because you've created this promise in an offer letter. It's not that you can't do it, it's just that it can create a hassle when you try to do it with that employee. Other examples would be, often you'll see in an offer letter, you are entitled to the following benefits while you're employed. And that could be a list of health insurance, premium payments or percentages of premiums that an employer will provide, retirement benefits, PTO or vacation, sick leave, those types of things. What I would suggest is, as much as possible, I would provide language in your offer letter or your welcome letter that indicates that the employee is eligible for all benefits that the company currently provides to employees in that particular role. And then you can list here, provide a list of here are the current benefits that the company offers, and that if you provide a specific grant to this employee, usually we see it with vacation or PTO. So you employee, we're providing you with 4 weeks of PTO. You want to make sure that you always reference any policy that would apply. So even though you're granting them 4 weeks, that grant, they still have to, or still must be provided in accordance with your PTO policy or vacation policy in place. So that would help with things like, does that 4 weeks carry over year to year if they don't use it? Do you pay it out on termination? All of those things, and we'll talk more about PTO in a minute, all of those things are covered in your policy, and we want the employee to know that your grant of PTO is governed by that policy. A couple other things, if you have an orientation or a training schedule for that employee, often that's great to provide them so they know what the next steps are once they come on board. Helps with expectations. Wage deductions and property form receipts. So for those of you that provide your employees with any sort of property, a laptop, an iPad, an iPhone or cell phone, and if you're providing an employee with that type of property, then you at least want to have a receipt form so that you can always track who you provided which piece of property to. In addition to that, if the employee fails to return it or loses the property at any point, if you want the option to try to deduct the value of that property from the employee's future wages, then in North Carolina, we need to have the employee sign a voluntary authorization giving you permission to do that. There are some limitations on wage deductions. We could probably talk all day about wage deductions, but a couple things to keep in mind. With property deductions like that, you as the employer, regardless of the deduction, always have to pay the employee at least the equivalent of minimum wage. So sometimes we might not be able to deduct the full value of the property from wages because we still have to pay that employee for the value of their time. Second key limitation, if we're talking about an exempt employee, so an employee who meets the exempt requirements under North Carolina law or federal law, and we pay them in most cases a set salary for the hours that they work, regardless of how many hours they work. If you make wage deductions from an exempt employee's salary, in some situations, or in many situations I should say, we can put that exempt status in jeopardy, which means that if that employee is working a lot of overtime and we make wage deductions for these types of things, then that employee can argue that they're actually not exempt, that we have broken their exempt status, and that they are entitled to additional overtime pay. So be careful with wage deductions. A couple other key points, emergency contact forms. So it's always good to know who you should contact as an employer if that employee has an emergency. Employment agreements. For those of you that want to have employees sign a non-compete, a non-solicitation, or a non-disclosure or confidentiality agreement, I throw those all in one bucket called employment agreements. Here in North Carolina, so if you're hiring an employee here in North Carolina and you want them to sign that type of agreement, in order for those provisions to be enforceable, those agreements need to be signed on or before the employee's first day of work. If we wait 2 or 3 months and after the employee's been working for us and then ask them to sign those agreements, unless we provide those employees with some sort of additional monetary incentive, those provisions, non-compete, non-solicitation, or confidentiality, may not be enforceable in North Carolina. So for those of you that do have employees sign the types of agreements, we want to make sure that those are provided to them and signed on or before their first day of work.
And Mimi, here's a question that's come up, and I want to make sure that I'm clear on it. What you said is that we can, if we agree up front that if we give an employee property and they don't return it when they leave, we can deduct it from their paycheck, but we can't go below minimum wage. Is that what you said?
For non-exempt folks, yes, you always have to pay at least minimum wage for all hours worked, and then of course you have to pay overtime. But okay, the key here is before that occurs, the employee still has to sign a voluntary authorization giving you permission to make that deduction.
Gotcha.
So if you wait until you're in that scenario and the employee, you've, let's say, terminated the employee and they have refused to bring back your equipment, we can't hold their paycheck. We have to pay them their final pay. And if they haven't already signed a voluntary authorization giving us permission to make at least some deduction, more than likely, if we ask them to sign it at that point, they're probably not going to. So this is why when you actually provide the employee with that property, you ask them to sign a voluntary authorization.
Got it.
And one other kind of key point, Eric, is in order to make at least some of that deduction, that initial deduction form that the employee signs has to have a value of the property identified on it. So the parties agree that the value of that laptop is $500, or the value of that cell phone is $500. So in order for that wage deduction authorization to really be helpful, you have to identify the actual value and the amount that will be deducted.
Got it. So, okay,
Yeah.
here's a question from the audience. So what about non-tangible things like, say, a negative PTO balance? Does that fall into the same type of requirements?
So PTO is a separate animal, and it's a little vague in terms of what the law requires here in North Carolina. So PTO generally under federal law is considered a wage advance. So if you provide PTO to an employee who has not earned it yet, it's almost like providing a loan or a wage advance to that employee, and we expect them to pay it back. So that particular issue in North Carolina is vague. So we don't have clear guidance under case law or from the Department of Labor. So what I would advise is, if you are in a position where the employee wants to take more PTO than they have currently earned, then at that point, when we are granting that PTO advance, we have the employee sign a wage deduction authorization that says, we are advancing you PTO, the value of that PTO is X dollars. If you leave employment or are terminated, then you authorize the company to deduct any unearned amounts from your final pay. So we at least have something in writing to back up that deduction if we're ever challenged.
Can that be kind of blanket as part of the new hire paperwork? It's like, all right, without having specific dollars or specific amounts, but hey, if you leave and you're in the negative on your PTO, we're going to take it out of your last paycheck.
So it doesn't ever hurt to have something like that in writing, almost like you would if you had an employee that managed a cash register. You could have them sign a document saying, if you're ever short in your cash register, you authorize us to deduct it from wages. It never hurts. The problem with some of those issues is that without that estimated amount, we then are obligated to, once we know that amount, we have to get the employee's voluntary authorization to deduct that specific amount.
Mm.
And we never want to have to ask for that authorization again.
Mm-hmm.
So my suggestion would be with PTO that at the time that you're actually advancing that PTO or approving that advance,
Mm-hmm.
you have the employee sign off on it at that point, which is where that's where you have your persuasive ability as well, right?
Mm-hmm.
They want the PTO, right? You're approving an additional, vacation time. And at that point, they want it. So
Mm-hmm.
that's when they're more likely to voluntarily sign your authorization form. So here's sort of how PTO is sort of a unique animal. The way that both the North Carolina Department of Labor and federal law under the Fair Labor Standards Act, the way they view wage advances or loans, those are items that we as the employer can deduct from final wages without having to have a voluntary authorization. So PTO is sort of a unique animal, and it kind of sits between a wage advance and how the Department of Labor views property value deduction. So because it's sort of this hybrid, I always would advise having a specific authorization in place.
Got it.
Great
Thank
question.
you.
Great question. Yeah. All right, last bullet, and I hope Eric, am I doing okay on time?
Yeah, we've got about 10 minutes.
Okay. So last bullet here, if you guys provided employees with a handbook, you're not obligated to have a handbook by law. There are certain policies that we should put in writing. But if you have employees sign an acknowledgement form, that's something else, the handbook and the form you could put with your new hire paperwork. All right, so we've talked, next slide, when we're talking about PTO. So PTO is something, or vacation time, guys, vacation time. It's not an obligation or requirement by law, but if you're going to offer vacation or PTO, then it needs to be very specific. And the reason is, once the employee accrues PTO, then there is a North Carolina law that says that that PTO can be deemed earned wages. And especially the issue comes up when we're looking at how much we have to pay out if that employee leaves. So let's kind of go through piece by piece some specifics. So you take a look at your current PTO or vacation policy and make sure you have clearly identified which employees are eligible to accrue PTO. For example, if you only provide PTO to full-time employees, and you as an employer can define what full-time means for purposes of your PTO policy. So have you identified who's eligible? Is it full-time? Is it full-time and part-time? Is it only full-time exempt employees? Or can it be full-time and part-time exempt employees? So make sure you've identified which employees are eligible. Second piece, how do employees actually accrue PTO? So there are two primary options. For small employers, it may be a lot easier to say, you know what, January 1st of every year, we're going to do a lump sum grant. We're going to grant all employees, 5 days of PTO, or all eligible employees 5 days of PTO. And for others, it might be better, especially for those of you that are using a payroll service who can track this for you. But you can also have employees accrue PTO over increments, depending on the hours that they work throughout the year. But you want to identify the method in your policy. Second, how much PTO are employees eligible to accrue? So some employers will identify it a couple different ways. They'll say there's a cap on the total amount that an employee can accrue. And once the employee hits that cap for the year, there are accrual pauses. The other option often is sort of a stair step, and most small business owners base that on length of employment. So for example, if you work up to 1 year for the company, you are eligible to accrue up to 3 days of PTO. If you've worked 1 year up to 3 years, you're eligible to accrue 5 days of PTO. If you work more than 5 years for the company, you're eligible to accrue 10 days of PTO. So some sort of stair-step, clear process. Fourth question, when do they start to accrue PTO? So we as the employer can decide, do they start to accrue that on day one? Do they have to wait to, if they accrue it on day one, are there requirements they can't use their PTO until perhaps they complete their 90-day introductory period? Or does your PTO start to accrue once they've achieved that 90-day introductory period? So we as employers have full authority to decide when the employee starts to accrue or when they can use their PTO. Number 5, in what increments can employees use PTO? So for example, can they use them in hour increments? Do they have to use them in 4-hour or half-day increments? Or do they have to use them in whole day, 8-hour increments, for example? So clarify in what increments employees can use PTO. Number 6, is PTO required, or can PTO, I should say, can PTO be carried over year to year? So you, as the employer, can determine what happens to that PTO at the end of the year if it's not used. In North Carolina, we call that a use it or lose it policy. State by state issue. Some states don't allow use it or lose it policies, but North Carolina says that's fine. But we have to clearly identify that in our policy. So two key things. If you do allow carryover, explain how much is allowed and what happens to any balance of PTO that is not carried over. So for example, indicate if you pay out the value of that unused PTO at the end of the year, or you could indicate that if it's not used, they lose it. So you'd state that the employee forfeits any earned PTO that isn't used by the end of the year and that can't be carried over. And then the final question here to me is the key question. North Carolina law says if our policy as the employer is vague or does not address whether or not PTO is paid out upon separation, whether it's termination for cause or resignation. If our policy is silent or unclear, then typically that means under North Carolina law and according to the Department of Labor that we are obligated to pay out the value to the employee as part of their final wages. If your policy indicates very clearly that you do not pay out accrued PTO or vacation upon separation, upon termination for cause, upon resignation, it clearly states that, then North Carolina law says that we do not have to pay out the value of that PTO. All right, so last slide, and then I think we're done, and unless there are questions, is one key thing I want to mention has to do with documentation for other paid benefits. And when I talk about these paid benefits, I'm not talking about insurance benefits. I'm really talking about any bonus policies that you have or commission or variable compensation arrangements. So under North Carolina law, these items, bonuses paid and commission or variable comp agreements, once the employee earns those payments are considered wages. And once they're considered wages, then we have to pay them out like we pay out wages essentially. So there's some things that we need to clarify. And the best way to clarify that is to make sure our bonus policies or our commission or variable comp arrangements are in writing and very clear. And a few things that need to be clearly identified in those documents. So I would suggest that you all pull those policies and pull those commission plans or variable comp plans and kind of do a self-audit and make sure that you identify clearly not just how much commission, for example, is earned on a sale, but when that commission is earned. So let me give you an example of where that can be a little confusing. So is that commission earned at the time that a client agrees to purchase a product or service from your company? Is that commission earned at the time that the client actually signs your engagement with the company or the contract? Is that is that commission or bonus, I guess, earned when the client pays the company for the sale? And what happens if the employee who makes that sale obtains the verbal commitment from the client on, hypothetically, January 1st of this year, resigns January 15th? The customer or the client signs your contract regarding the sale on the 18th of January and then pays you February 1st. Has that employee earned that commission? So the key thing we need to think through is when do we want to pay that commission? If we want to pay it on the time, at the date that the employee actually gets the commitment from the client, then let's clarify that in the agreement. If we want to wait to say that commission isn't earned until the company actually receives payment, then we need to clarify that. The additional thing we want to think through is, are there any conditions around earning that commission? So for example, does the employee have to be currently employed by the company in order to earn that commission? And if so, when do they have to be currently employed? Does it have to be on the date that that commission is paid, as opposed to the date the sale is entered into? So if there are any conditions surrounding when and how you want to pay that commission, that also needs to be in writing in your agreement. So let me make a couple of points here on a bonus in particular. For those of you that have specific bonuses outlined for your employees that identify key expectations, and if the employee meets those expectations, they will earn a specific bonus. So for example, this could be an attendance bonus. So if you are on time every day and work your entire schedule for the next 30 days, the company will provide you with a $100 attendance bonus. Or it could be a very specific performance bonus. If you hit these specific dollar figure revenues from sales, then the company will provide you with a 2% bonus on those sales. So if there's a very specific outlined bonus policy, and if those bonuses are provided to non-exempt employees, so these are employees who are eligible for overtime under state and federal law. If we provide those bonuses to a non-exempt employee, we have to include those bonuses as payments within the regular rate on which overtime is based. So if that employee typically earns $10 an hour, that is typically the regular rate on which we base time and a half for overtime. But if that employee earns a bonus, and these are what we call non-discretionary bonuses, meaning that there's a clear outline to the employee. If they meet those expectations, they will get this payment. Those are non-discretionary bonus payments. If we pay that bonus payment within a pay period when the employee worked overtime, we have to include that payment and recalculate the regular rate. So it will increase their regular hourly rate on which overtime is based. So just keep that in mind if we're providing non-discretionary bonus payments to a non-exempt employee.
But it's just for that particular pay period, right?
Right.
Gotcha.
Right.
Cool.
And it can be a little complicated depending on how our bonus is calculated and over which pay period we have to look at in terms of overtime. But yes, Eric, essentially it's the pay period that the employee receives the payment.
Cool.
And last kind of key thing, think through, and when you audit your bonus or commission policies, think through if you've got commissions that are based on sort of a recurring payment from a client, make sure you think through how you want to handle that once an employee is no longer employed by you. So we want to be able to clearly, assuming that you don't want to continue paying that former employee for commission payments ongoing, we want to have clear language in our commission plan or our bonus plan that identifies the employee and clarifies for the employee that once they are no longer employed, they are not eligible to receive any additional commission. So take a look, audit your commission plans, your bonus policies, and let me know if you guys have any questions. And Eric, I think I am done.
Lots of great information.
Unless anyone has questions.
Yeah, so a couple of questions, and one, if you're out there, if you do have questions, I know we're running a little late. Get them into the console, and I'll get them through here. But we've got a couple already. The first one was you said that you had a link to the NC State new hire paperwork. What is that?
So it's a link to North Carolina's new hire reporting website.
Yes.
So so all employers in North Carolina, and most states are this way, have to tell the state when they hire a new employee. And the purpose primarily is so that the state can find people who might owe child support payments. So typically, if you work with a CPA or a payroll company that processes your payroll, most of them are making this new hire report on your behalf. But one, you want to clarify that they are doing that, so make sure you confirm that with your provider. If they aren't doing it, or if you process payroll and new hire paperwork yourself, then I'm happy to send you the link where you can register online, and you just go, when you hire a new employee, you go into the system and you update it and essentially notify the state that you've hired this employee.
And so what is that link? Do you have it handy?
No, but I'm happy to email that out.
All right, cool.
Or I'm happy to give that to you, Eric, to email out to anyone who's registered.
All right, cool. And then the other question kind of came up with the collusion on salary. Do you have any good tips on getting appropriate salary information for specific positions?
I think the best practice would be to look for organizations that compile those salary summaries based on industry. And I think that's primarily the best way to obtain that information. So you're purchasing it from an unbiased third party. And so then we can avoid any antitrust concerns.
Like a state association that does this for your specific industry. Got it.
Exactly. There's some HR consulting firms that compile that as well. So there are multiple resources. If I'm happy to put a list together of options. And Eric, I'm not familiar with your salary.com. I don't know if they provide something similar.
Yeah, I'm not sure how right it is, but we at least looked at it in the past. Sometimes on there, it's really hard to kind of get a handle on the specific jobs because they have level 1, level 2, level 3, level 4, and it's hard to kind of sort through that. But at least we've used it as kind of a good starting point.
Yeah, but I'm happy to send some specific options, especially here in North Carolina. If anyone would like, just let me know.
Outstanding. All right. Well, listen, Mimi, thank you so much for your time. I really appreciate it. And just to everyone, we've got 2 more coming up on extending this topic out through employment classifications and then employee terminations and how to handle that properly. They're coming up in the next 2 months. If you want more information on that, go to our website, technologyassociates.net/registration. And thank you all very much.